First case is State of Ohio versus Mohamed Reeda. Each party will have 15 minutes to present their arguments. The appellant may reserve up to 5 minutes for rebuttal. If you do plan to reserve time, please let me know as I'll be keeping track of the time. The arguments are being recorded. When you present your argument, please introduce yourself, keep your voice up, and remain behind the podium. You should not use the names of children, minors, and victims during your argument. You can refer to them by initials or terms like the child. We have read your briefs and we're prepared to proceed when you are.
Good morning, Your Honor. May it please the court, Louis Grube here on behalf of the defendant appellant, Mohamed Reeda, and I would like to reserve 3 minutes for rebuttal, please. The prosecution of this case was lazy. The state was extremely slow to provide discovery. It never justified any of the delays with anything like an evidentiary record. Did not even respond to the speedy trial motion, forfeiting any claim of tolling in this case. There's nothing left but to discharge my client. I'm planning on spending most of the time this morning on the speedy trial issue, but obviously there are several other assignments of error. Half of them would be new trial issues, half of them would affect the sentence and scope of the sentence. I'm happy to answer any questions about that, but unless the court wants to direct me elsewhere, I'm going to talk about the 54 days that I need. The state has conceded that 36 days passed on the speedy trial clock, so all we have to find are 54 more days where time was not told. I'd like to talk about a few problems. The initial error in this case was placing the burden of addressing tolling at all on my client. You'll note from the trial judge's ruling, this is docket number 224, page 4, saying that Reeda didn't account for any tolling periods and therefore did not make out a prima facie case of statutory speedy trial violation. That is, of course, not how the dynamic works in this area. My job, my client's job, was to establish a prima facie case. That just means did enough days pass from arrest, from the beginning of the clock, to trial. Now, I think the time here was something like 270 days from beginning to end. There's really no argument that a prima facie case was not made out, and so there is at least legal error by shifting that burden to my client in that order. Just to give you the numbers here, what he did do, what Mr. Reeda did do, set out that 274 days passed between his arrest and the motion. That's page 1 of the motion to dismiss. And he argued, actually, he did address tolling. He said that 162 days of that period, time definitely was not told. That's pages 3 to 5 of the motion to dismiss. Now, not only that, he later followed up with a helpful calendar. And I just addressed the court. This is in docket number 133. This is March, April, May, June, July, August, September, October, November, December, January of 2023 and 2024. My client did in fact address tolling. The days that we are arguing count are marked with a star, and the days that we are arguing time was told, at most, are marked with an X. So there is a record here. My client made the record. He met his burden. The state did not meet their burden. The state did not even file a written response to the motion. There was no hearing on this. The state did not ask for a hearing so that it could establish tolling. The state filed some motions to continue that have some reasons, and I'm happy to address that for the court. But the baseline here, parties are expected to make the argument that they are going to rely on appeal in the trial court. This is the cardinal rule of appellate practice. I have to double check so that I set forth my either error arguments or plain error arguments so that I can be clear to the court. I make my arguments to the court based on the standard of review that applies and based on what happened in the trial court below. Now, the state did not actually oppose the motion to dismiss. There's no written response to it.
And your argument is that the time that should toll is the reasonable time to respond.
Well, certainly there are several periods where my client filed certain things that would have told the clock. Now, I think there's a big existential question here, which is like when the state doesn't file a response, are you still going to toll all the time for them to file a response? Obviously, the trial court is sitting in review of what actually happened.
Your main argument, I believe from your brief, and I'm asking this is that the whole entire time that that's sitting pending, it shouldn't count?
I am arguing that the state forfeited and therefore the whole time should count. If the court somehow gets past the forfeiture issue and into the details, which, like, if you read the state's brief, none of those arguments were actually made to the trial court. So the court doesn't even really need to accept them. They can be sort of pushed aside as forfeited. Now, we've cited several cases where the state forfeits errors, just like any other party. I mean, the Gwynn case off the top of my head, that's the 2019 Gwynn. And then Rue, 2020-Ohio-6706, Hickman, 2024-Ohio-5747, that's in paragraph 23, footnote 2. These are cases where the state didn't make an argument to the trial court and therefore was not permitted to make the same argument to the Court of Appeals. This is a layup speedy trial case. I don't know how it could be any clearer. I mean, all of the arguments made have been forfeited. But getting into the details, let's talk about the motion in limine, because that's kind of an easy one. The motion in limine was filed with the idea that maybe this trial on August 4th was actually going to happen, which of course it never was. It was set for trial on August 4th on July 27th. By that time, the judge had known for a month that she had scheduled another trial with priority for the same day. Nobody expected that trial to go forward. State didn't actually respond to the motion in limine until that trial date had been canceled. So again, I don't know why you would toll any of that time to respond. It was later ruled on eventually, but way down the road.
But isn't there clear case law on that? If there's another case that has priority and the judge puts that on the record, that does toll time? Like
The judge...
unavailability of the court?
Sure, yeah. I mean, the court can do that if the court is continuing the case, but then that begs the question why the court even set the trial for that date. Does that make sense? I don't understand.
Typically, trial judges set multiple trials on one date and then prioritize multiple trials are going forward, which one goes forward.
I understand that.
And then we have case law, right, about that?
Yeah, there is case law about that. I understand that. What I'm saying is that by the time we got there, motions in limine, there's no like rule for deadlines in criminal practice, right? So like, for example, there's no rule under Rule 16 that my client had to file anything when responding to discovery. There's no rule saying, hey, you have to file your motions in limine by a certain date, but you do have to file them before trial. So setting an August 4th date puts my client on all sorts of obligations to sort of set up his defense. We're talking about a week. This was set a week ahead of time. So that motion in limine, it was filed. We're conceding some degree of tolling there, but the court should treat it as days, not weeks, because it's just totally impractical. The judge put my client on the clock to file this motion in limine and then canceled trial knowing what was going to happen. That's fascinating to me, but it's just wild. It's wild because if you know this trial isn't going to happen for months down the road, why put my client on obligation to file a motion? Under the circumstances, I mean, I could understand a couple days of tolling. The trial was canceled August 3rd. So, sure, okay, toll it from the motion in limine filing to August 3rd, but that doesn't buy us months and months and months till the later trial. This discovery request is also a thing.
Does that then put the onus on the defendant to revoke their
pull their motion in limine?
In limine because the trial isn't pending? Pending imminently.
I mean, that's scary. If the court's going to say that, it's scary because then that sets up this trick that a court can play. Let's schedule a trial, put you on the clock for your motions, get your motion filed, and if you just don't remember to withdraw it before I cancel this trial date, we've got tolling until January.
Well, there's an array of what's, if it's a civil trial or a criminal trial that's coming up, people do file motions 30, 60 days ahead of the trial.
Certainly in civil practice.
How do you decide what time should be told there?
Yeah, this court's going to have a really difficult judgment call to make. I mean, how many days? Judge Lanzinger, how many days does it feel like to you? I can't answer that question for the court. What I am going to argue is that the court knew exactly what was going on, and tolling anything more than like a week, maybe 10 days, is crazy in that August. The discovery request is also an issue. I mean, if you look at the state's case, it's relying on Palmer, right? So this discovery request is made, the state files it, Mr. Reeda is under no obligation to put on the record that he did in fact respond. The state bears all the burden to demonstrate tolling in this area, but even if you accept their argument, under the Palmer case, you only toll starting after a reasonable time to respond. So that's 30 days conceded. I only need 54. So let's start talking about where I'm going to find the other 24 days, right? I mean, under their own argument, under the Palmer case, that is 30 days for me. I am now at 66 days. So let's talk about the discovery request. I need to address this. The state talked about the lack of a response. It's not in the record. The state bears the burden to build this record. This is just like the Ragsdale case. I was just here a couple months ago arguing the Ragsdale case. State bears the burden to demonstrate. So if the state wants to say, oh, this discovery request was never responded to, put it on the record. Put it in your memo opposing the motion to dismiss. Say what the issue was. This is about delay. This is about delay that affected the trial, and the state did nothing to establish that any delay actually affected the trial at all. There was no filing. There was nothing. Now I know outside of the record that was in fact responded to. The best I can say here today based on the record is that there's nothing in the record about when my client responded to the discovery request, and the state bore the burden to establish that that was a delay that he actually created. By leaving the record completely bare, it's an ambiguity. We know under Ragsdale, all ambiguities cut in favor of my client. That gets me well over 60 days. The state is trying to argue something like 150 days from that discovery request to trial. I'm looking for the number, but it's they're trying to say that, well, we made a discovery request in July or August, and so trial was timely the following January. I'm counting, 73 days between September 29th, 2023 and December 11th, 2023 that there is no reason trial cannot be held during that time. Absolutely no reason. And I see I've got 4 minutes left. If there aren't any specific questions about the record, I'd like to reserve all of that. Thank you, Your Honor.
Good morning, judges. May it please the court, my name is Rick Raley. I'm appearing today on behalf of the appellee of the state of Ohio and Summit County Prosecutor Elliot Kulkovich. I'd like to introduce Ms. Jamie Morris. She's now one of our new appeals prosecutor. You'll be seeing her more often. Like Mr. Grube, I'll limit my discussions here to this speedy trial issue, and I guess we'll start out in front of what's been forfeited and what's not been. When you look at the case law, it talks about forfeitures of error and claims of error. The state is not saying there was any error. The state is saying that the trial court's order was appropriate, and it was an appropriate ruling on this motion. And while it is true that this discussion of the burden shifting framework for speedy trial issues is correct for Mr. Grube, I would point out this is not a true evidentiary question. The evidence is essentially the court's docket. It's judgment entries. That's all the court has to review. And in fact, the defense, although it's not their burden, in their motion already put it on the trial court's radar that they have to think about tolling when they're ruling on that motion. So, I propose my calculation of what I think after the tolling is. The trial judge did a very good job of going through that herself in her order. She lists a variety of tolling events that occur. And I would say, there's a discussion essentially from Mr. Grube that a lot of time after August should not be tolled, but during that time there's motions to sever being filed, there's motions for sanctions being filed by the defendant, all tolling events. There's also a motion to dismiss for the speedy trial. That itself is a tolling event, so that is on December 29th.
What's your answer to this assertion that if a motion is filed and it hasn't been ruled on, that there's this long period of time that you can use as a tolling time?
So,
if you say something's 94 days long after something's filed, is that really reasonable in that circumstance?
I think if I were here arguing to you that motion in limine was the only thing tolling time, I'd be in a lot of trouble. But that's not the only thing that happened in this case. There were a lot of motions beyond that that were filed beyond that. I will say it's reasonable based on the issues that are raised in the motion. So if it's a motion to suppress that raises a novel issue of law that requires a lot of research and a lot of evidence, that's going to toll time for long. A motion eliminated by itself could be something that's very simple and something that should not toll very long. I will say in this particular...
Like a motion to dismiss based on speedy trial, which does toll time. Mm-hmm. What's a reasonable amount of time there for tolling? How do we decide that?
I think it's a good idea typically for an appellate court to avoid timeline, like a time strict on deadline. But for something like a motion to dismiss for speedy trial, that does involve some research by the judge that should take multiple weeks at best, I would say. And that gets us pretty close to when the actual trial occurred here, because it was late December that motion's filed. And I would also point out there is a finding in the record that there was an unavailable court for the original trial date, and the first reasonably available date based on schedules was January 5th. So that period right there is cut. So with all of that tolling, I do think that that the trial court decision was appropriate. My calculations are more appropriate than what's been put forward to you this morning. I will address this issue about the reciprocal demand. It is not in the record at all that there was an official response. Mr. Grube last night emailed me text messages and emails indicating there wasn't an exchange of discovery. None of that is in the record. There was never a response filed. So for that, I still think that this court can rely on the lack of an official filed response as determining the tolling event.
So if somebody files a motion for discovery, which they have to do under Iowa law, if they want discovery, and they do it at the beginning of the case, then all that time is told until the trial 6 months later?
Well, if the defendant's filing a motion for discovery, that according to the case law, I would have 30 days myself to respond to that. There is no such limitation that exists for reciprocal demand that has not been established yet in the case law. You could apply 30 days, you couldn't. I would just say that if that's out there and you're going to, for instance, there's here evidence that there's a center console presented at trial and that was never provided in discovery. I think that it's something to rely on, what the record shows about when the responses were and what the defense has shared with the state. With that, if there are any other questions about anything else, I can answer them, but if not, please affirm the trial court's order. Thank you, judges.
I would just quickly like to apologize for receiving a text out loud and during argument. I wanted to do some research while opposing counsel was arguing. The first thing I'd like to start with is the idea that forfeiture is only for assignments of error, right? I didn't cite to cases where there were state's appeals. I cited to cases where the state forfeited arguments. So I'm going to read to you from First Gwynn. Paragraphs 10 to 11 address the forfeiture. But the state forfeited its argument is the first several words of paragraph 10 of Gwynn 2019. It was an argument issue. Going to, let's see, I'm in the Hickman case, footnote 2. The state argues in this court, but it forfeited this argument. Sorry, I'm paraphrasing here. And then on the Rue case, paragraph 64, also, I don't need to beat the court over the head with this. These are all cases where arguments were forfeited, not assignments of error. The state can argue anything it wants in the trial court, and it can forfeit anything it wants by failing to make that same argument in the trial court. The entire principle of tolling is forfeited here. But even if we move on to the merits, right? I want to address that too, because the court might decide that it's easier to just skip this forfeiture issue and get into the details. My friend just said that the court shouldn't pick days. Shouldn't go through with a fine-tooth comb, pick how many days. That's exactly the approach that was taken in Ragsdale, where this court reversed, saying that it wasn't worth going through all the details. That at some point, you reach a point of absurdity. There is too much time has gone on, not enough adequate reason for tolling. It is okay to just take this as this monolithic delay and just say it's not okay to take this long to take a trial from indictment to trial. It's too much. It just is too much. In this case, it just is too much. Simple motion should toll for less time. That is one of the greatest concessions in this case so far. What is so complicated about a motion in limine? Exclude anything we haven't been provided by the state so far. Or, let's have the trial today, but keep it all out, right? What's complicated about that? That's basic. It's basic. Exclude evidence that hasn't been disclosed to us? What about speedy trial when there's no response? How much time do you need to decide a completely forfeited speedy trial motion?
I do think motions in limine are different than all of these other motions that you're referencing, because motion in limine are preliminary rulings and not rulings until trial.
Yeah, I mean, it's,
I mean, do you think there's a better argument on some of these other motions that should be ruled on before trial than one that doesn't necessarily get ruled on until trial?
yeah, I think it'd be fair for the court to treat that very differently. Yeah, I actually don't know why you would toll automatically time for a motion to eliminate now that you mention it, because the problem becomes, well, okay, so put them on the clock for this motion to eliminate and then extend the trial, and you never actually rule on it until you're on the bench.
Right.
So that does make sense to me, actually, Your Honor. I think if the court takes that to its natural conclusion, I mean, the state doesn't often respond to these motions anyway because they are filed so close to it. What really happens in practice is that the trial judge gets the written motion, takes a look at it, figures out what they're going to deal with when everybody arrives on the first day of trial. As it should be. Trials are hard. Trials are hard, and the state has a great burden. I understand that. Providing discovery timely, getting the case to trial on time, not extending it out. Step up, do the work. It's speedy trial. There's a statute that says a clear number of days. The state knows this going in. They know in advance what their obligation is. This case could not be any clearer. So if the court doesn't find that the whole tolling principle is forfeited, there are at least 54 days of time that was not tolled. And this court should discharge Mr. Reeda, and we should all move on. Thank you very much.
The court will take this matter under advisement and issue a ruling in due course. The clerk of courts will mail you a copy of the decision on the day it's released. Also, the decisions are posted on the Ohio Supreme Court website. Thank you both for your presentations today.
Thank you, Your Honor.